Hi, so in the next 12 minutes, I will be running you through my presentation Corporate Law 2, and the topic is independent directors. Through the material, I will be dealing with the multiple aspects of corporate law, including the very basic standards. So first of all, I will start by introducing you to the concept of independent directors and principles of corporate governance. That is, we'll be tracing back so as to the reasons for the development of the institution of corporate director and how is that related or stands within the institution of corporate governance. Secondly, we'll be looking at the law in India with respect to the concept of independent directors. We'll be looking at the 2013 Act, Listing Agreement, and 1956 Act. Thereafter, we will look at position under different jurisdictions, including United States of America, United Kingdom, Germany, etc. We will look at the development of law in these countries, and we'll also look at the actual law that governs institution of independent directors in these countries. Thereafter, we will look at a bunch of jurisprudential issues that arise out of the whole institution of independent director. These include issues with respect to the appointment of an independent director, liabilities of an independent director, functions of an independent director on committees, various committees they are on, the reasons for them being on those committees, non-executive directors when compared to these directors, and remuneration of independent directors. We'll also be contrasting this with the remuneration of the auditors, right? Thereafter, we will look at the existing laws and the drawbacks of the existing laws. And finally, coming to a conclusion about whether the institution of independent director in India is worth it. I will be taking first 7 minutes to perhaps speak about first chapter, the law in United States and United Kingdom and Germany, and finally I'll be also talking about a few jurisprudential issues. Prakhar will talk about the legal position in India. He will be talking about the existing law and its drawbacks and a bunch of jurisprudential issues. So, starting with the development of the institution of independent director. If we look at it carefully, we will realize that the institution of independent directors and the events that resulted to the development of independent director are directly related to the development of the institution of corporate governance. The development of joint stock companies resulted in development of an institution wherein the shareholders, the owners of the company, were separated from the managers of the company. A large number of owners of a company, the companies were forced to have a separate management that could effectively and efficiently run the management, perhaps relying on the basis of the idea that too many cooks spoil the food. Considering the same, there was a segregation created between the ownership of a company and management of a company. Now, if we look at it carefully, we would realize that this results in many practical problems, perhaps one of the most important of all of them being the fact that how could managers and the management of company be controlled in such a manner so that it caters to the it effectively caters to the interest of shareholders and other stakeholders and adheres to basic laws and does not violate the same for their own benefit. The same came out of a resultant development of corporate governance, which perhaps started in the United States of America in the early 1950s by a contribution from academia in the United States and a number of scandals that were discovered in the late 1990s and early 2000s, which perhaps resulted in establishing of multiple committees that at a subsequent stage made multiple recommendations for development of the institution of corporate governance in general and institution of independent directors in particular. The same happened in case of India, wherein there were basically three factors that resulted in development of the institution of independent directors. These included the 1991 liberalization, because of which there was a requirement to attract a foreign capital in India. B, the development happened due to scandals that were discovered in the United States. And third reason for the development was that there were a number of committees established that seek to install corporate governance within India. These include Kumar Mangalam Birla Committee, which was established by SEBI in 1999. Then at a subsequent stage, they established Narayan Murthy Committee, which made its recommendations. Parliament had its own committees. Ministry of Corporate Affairs had its own committees, and they gave a number of guidelines as to the development of the institution of independent corporate governance in general and independent directors in particular. These committees, after their recommendation, the question arises with respect to the definition of an independent director. Who could perhaps be an independent director? What are the recommendations that they give with respect to the independent director? So if we look at everything carefully, we would realize that the very idea of independent directors has developed from the basis of a definition for independent directors that includes perhaps the kind of qualifications that an independent director can have, that perhaps includes the kind of background that an independent director may have, that perhaps includes the kind of remuneration that an independent director can be included, independent director family relations, and etc., and the kind of shareholding and the interest that an independent director has. Now, subsequent to that chapter, if we look at law in different countries, we would realize that law in the United States with respect to independent directors at a major level governed by Sarbanes-Oxley Act of 2002, which speaks with respect to the auditorial requirements and requirement of independent directors over auditing committees. So this particular act basically used its own. Now, it came at a time when there was Enron scandal discovered, in which there was some accounting illegal activities and there was collusion between the management, the accountant, to defraud the shareholders. And this particular act, along with listing requirements of NASDAQ and NYSE, also forms the basis of law in the United States, separately giving directions with respect to appointment, remuneration, and presence of stakeholders and shareholders of the committees. Thereafter, we are also talking about the United States. There are individual states in the United States which have their own laws, and they also govern the institution of independent director in the United States. Then we go on to United Kingdom. In United Kingdom, the law developed subsequently with establishment of number of committees such as the Cadbury Committee, the Greenberry Committee, and subsequently the substantial other committees and their recommendations with respect to the institution of independent director in particular and corporate governance in general. So they gave a number of recommendations. These recommendations were looked at. The interesting thing about the law in the kingdom is that it is not mandatory to follow law, but it is mandatory to tell so as to why a company did not follow that particular law or the requirements with respect to the institution of independent director and corporate governance. Otherwise, they are free to not to go by. We see that this particular kind of institution of independent director develops because of the free market capitalist attitude of the American and British economies. They are inclined to going forth for this. Then we talk about Germany and the German case. In Germany, there's nothing like an institution of independent directors, but there is a system of twin board, wherein there's a managerial board which controls the day-to-day functioning or attributes to the day-to-day functioning of a company, and then there is a supervisory board, also known as Aufsichtsrat, which basically has members from management, members from the managerial board, members from the shareholders, from the workers. Basically, interest of every stakeholder is represented. Now, under such circumstances, the interests of shareholder, the requirement of independent directors does not exist, because everyone is over the supervisory board is representing a conflicting interest but because everybody's interest is being represented by conflict, it is being made sure that the company resorts to proper absolute functioning. Now, an interesting thing about this is that while the British and American law, and perhaps for that instance Indian law, make an attempt to have an independent director over the board so as to ensure that independent director is completely made, hence they presume that he will act in such a manner that is not in interest of any of the parties, is in a great contrast to the German law, which makes sure that every interest perhaps is represented on the board, and by a conflict of interest we'll have such a situation or such a paradigm in which every interest shall be secured and ultimately the interest, the company will properly function. Hereafter I'll talk about different jurisprudential issues. One of the most important jurisprudential issues arises with respect to liability of an independent director. What we see is that the institution of liability of an independent director has developed in India over time. Under the 1956 Act, there was nothing like an independent director. Independent directors were appointed for private companies via an agreement, under the provisions of the listing agreement then. Because of that, every director had an equal standing, including the independent director, even they might not have had enough access to the management or day-to-day function of the company. They were presumed to be at an equivalent footing with every other director. As a consequence of this, there were a number of instances when an independent director, despite of not having the knowledge, was punished. Say, for instance, in the case of Bhopal gas tragedy, and in the case of Satyam. Satyam scandal, Satyam scam, where they were punished despite of them not having a role. This resulted in multiple independent directors resigning, right? Under the 2013 Act, the position has changed substantially. Under the 2013 Act, the liability of independent directors has been specifically made with only respect to those cases when they have been involved in taking decisions or have been a part of that decision and not otherwise. They cannot be held to be liable for wrongs in institutions that they perhaps never did or never resorted to. In addition to that, I will also be speaking about functioning of an independent director when it is compared to someone on the lines of non-executive director. So the presence of non-executive director in a company is basically in order to secure the non-executive director's position, in terms of the fact that non-executive director is in fact person on the board whose main function is to basically give some form of skill set to the board to look after the board in such a manner so that the board might benefit. So non-executive director is purely on the board not to run day-to-day management, because of the certain kind of skill set that he or she brings to the board, and that's the reason why we have him in the first place. Independent director, on the other hand, is there for a certain purpose that is defined and laid out well in the statute. So independent director has more statutory role, pre-assigned role, as and when compared to non-independent director, right? Non-independent director's role is rather more related to the role ascribed by the committee, the directors, or the reason for which they are initially on the board of directors. In addition to this, independent directors are on multiple committees within the multiple committees within the meaning of the statute. They are to be present on audit committee, they are to be present on public relations committee, and they are to be present on other committees, say for instance remuneration committee, and they're supposed to determine about it. So this is particularly to ensure that the interests of shareholders are well protected. In addition to this, we'll look carefully. Remuneration of an independent director is limited, and the reason for the same is so that he cannot be remunerated in such a manner that it has a negative influence on his overall presence within the committee, and he is not able to be badly or negatively influenced by extraordinary remuneration or a remuneration that is extraordinarily high, right? So there are limitations on the kind of shareholding you can have within the committee, on the amount of linkage you can have in the committee. Now this, when contrasted with non-executive directors and auditors is different because of the kind of role that they play and the kind of checks and balances that are in case of others. In case of non-executive directors, the roles that they play on the board are very different from the roles that are played by independent directors. So even if a non-executive director is not independent, it's highly likely that he is going to execute his function of expertise that he brings on the board of directors as well and as good. Right? He doesn't need to be independent to implement his very function on the board of directors. But in case of independent director, if his independence is influenced by pecuniary perks, it's highly likely, or by personal perks, it's highly likely that he's going to do. And the similar regulatory paradigm does not exist for auditors, because auditors are basically have a very different regulatory regime when compared to independent directors. Their regulatory regime is such that they can exercise and execute their professional duties, can be remunerated for the same, but at the same time they can be also controlled for the same. So say for instance, an auditor is answerable directly to the general meeting, can be removed by a simple resolution, can be a part of any form of general meeting, etc. He has legal responsibility, liability in case, which is very much far more harsher than the liability of an independent director if an irregularity is discovered. There are limitations, the kind of role that an auditor can play in terms of the limited role, in section 144 prescribes that an auditor cannot go beyond certain roles that are prescribed in the law, and so on and so forth, right? So we see in the existing law, there's one fundamental drawback in the most important sense of the word. And that fundamental important drawback is that institution of independent director hasn't been designed in the way it should have been in the Indian context, and does not fit the Indian context properly. Because in India, we don't have diffuse shareholding. Most of the shares are held by big, large corporate firms, which hold and control substantial shares in Indian companies. And because they hold substantial shares, they are the ones who can appoint the independent director, control the institution of the independent director, and independent director might not be as free in this case. Also, we do not need the institution of independent director because those are the ones who are actually in control of the company. So the shareholders' interests are not have to be protected because they're also being represented on the management, right? So the institution of independent director in the Indian context has a very limited role to play in terms of the protection of stakeholders, in terms of protection of investors, small investors, and so on and so forth. So that's what we kind of expect from this particular institution of independent directors in India. And we think that the role of independent directors has to be modified, and we have to have substantial number of changes on with respect to the institution of independent directors. These changes include things on the line of something like having some sort of qualification for them, such as the qualification of chartered accountants and company secretaries, having a directory of independent directors, they can appoint, etc. They have so many qualifications associated with them, so many reasons for them to be disqualified, that it becomes almost impossible to have an institution when disqualified. So that's